He was sitting on the front steps of my house when I pulled into the driveway, just sitting there with his son asleep on his lap and a single duffel bag at his feet. It was 41 degrees and neither of them had a proper jacket. I turned off the engine and sat there for a second. Just 1 second. That was all I allowed myself. Then I got out of the car. "Come inside," I said. He looked up at me and I could see it immediately. That particular kind of exhausted that has nothing to do with sleep. His eyes were red but dry. He had probably cried in the car and then made himself stop before he got to my street. That is exactly the kind of thing my son would do. I took the duffel bag. He carried his boy. Inside, I put the kettle on and didn't say anything while he settled the little one on the couch with a blanket. My grandson was 4 years old. He slept the way small children sleep when the world has been too much, completely, like a stone dropped in still water. My son sat down at the kitchen table and I put a mug in front of him. "She changed the locks," he said. I nodded. "I came home from work and my key didn't fit. She had texted me to say she'd done it. That was it. Just a text. I knocked for 20 minutes and she wouldn't answer. The neighbors were watching." He wrapped both hands around the mug. "I had Caleb with me. I had just picked him up from preschool. He kept asking me why we couldn't go inside." I sat down across from him. "My name is Harriet. I am 63 years old and I have spent the last 22 years working in financial compliance. Before that, I spent 8 years as an auditor. I know how money moves. I know how paper trails work. I know what it means when someone acts fast and quiet, which is exactly what my daughter-in-law had done. She had been planning this. That's the thing people miss when they hear a story like this. They think it's an explosion, a blow-up, something that happens in a moment of rage. But you don't call a locksmith in an afternoon. You don't just decide on a Tuesday to remove someone from a home. You think about it. You prepare. You make sure the timing is right. She had been preparing. My son's name is Kevin. He is 34 years old and he is a project manager at a mid-sized construction firm in Columbus. He is good at his job and he is genuinely kind, which in my experience means the world has occasionally taken advantage of him. His wife, I'll call her by her name, which was Renata, had moved into the house they shared 3 years ago. The house was in Kevin's name. He had bought it before they married. He had made every mortgage payment. The property taxes, the insurance, the new water heater last January. All Kevin. Renata worked part-time at a dental office and had contributed to groceries and utilities on and off over the years, but never in any consistent or documented way. What she had done, I would learn, was consult someone before she changed those locks. She had done her homework, and whoever she had spoken to had told her something that is technically accurate but dangerously incomplete, that in Ohio, a spouse has certain rights to a marital home regardless of whose name is on the deed. That is true. It is also not the whole picture. But I didn't say any of that yet. Not that night. That night I just listened. Kevin told me it had been bad for about 8 months. Not explosive, he said, just cold. She had stopped talking to him about anything real. She came home late and gave vague explanations. She put a passcode on her phone that she hadn't had before. He had asked her twice if she wanted to go to counseling, and both times she had said she would think about it and then never brought it up again. He had tried. I believe that. Kevin is not a man who gives up on things easily. Then, about 2 weeks before she changed the locks, she had told him she thought they should separate. He said okay, he agreed it wasn't working. He wanted to do it properly. Mediation, a real plan. Something that protected Caleb from being caught in the middle. He had been reasonable. He had been calm. She had apparently mistaken that calm for weakness. "She told me she spoke to someone," Kevin said, "a lawyer. She said she was entitled to stay in the house and I should be the one to leave." "Did she give you anything in writing?" "No." "Has she filed anything with the court?" He frowned. "Not that I know of." "Then she hasn't," I said. If she had filed, you'd know. I got up and refilled the kettle because I needed a moment to think, and I have always done my best thinking while doing something small with my hands. Here is what I knew. Kevin owned the home. His name was on the deed. His name was on the mortgage. Ohio does recognize spousal rights in a marital home, but changing the locks on a cohabitant, especially one whose name is on the mortgage, is not a legal eviction. It is, at best, a civil dispute. At worst, it is a form of domestic abuse recognized under Ohio law. Removing someone from a home without a court order, regardless of marital status, is not something a locksmith and a text message can accomplish legally. Renata's lawyer, whoever they were, had given her a piece of information without giving her the full context. That happens more than people realize, especially in initial consultations where someone is told what they want to hear. I came back to the table. "You have not been evicted," I said. "You have been inconvenienced. Those are two different things, and tomorrow we are going to make sure she understands the difference." Kevin looked at me for a long moment. "What are you going to do?" "Nothing dramatic," I said. "I'm just going to make some calls." The first call I made the next morning was to a locksmith, not to break in. I want to be clear about that. I called a locksmith because I wanted a quote and because locksmiths, as a professional community, are usually willing to talk about what they can and cannot legally do. The man I spoke to, very helpful, very matter-of-fact, confirmed what I already suspected. In Ohio, a locksmith who changes locks at the request of one spouse in a home where another spouse also legally resides can be held liable if the excluded party can demonstrate they had legal right to access the property. Most locksmiths know this. The one Renata had hired, apparently, had not asked enough questions. The second call I made was to Kevin's mortgage servicer. I had him on the line with me. We confirmed that his name was the sole name on the mortgage, that he was current on payments, and we asked what the servicer's position would be if the homeowner were being denied access to the property. The representative transferred us to a supervisor who was very clear. A mortgagee being locked out of their own property, especially without a court order, was something they took seriously and would document. I wrote that down. The third call I made was to a family law attorney I had worked with tangentially about 4 years ago on a compliance case involving a divorce settlement. Her name is not important, but she is sharp and she does not overstate her position, which is rare. She confirmed everything I had already worked out and added one thing I hadn't fully considered, that Renata's action, if Kevin chose to pursue it, could actually affect her position in any subsequent divorce proceeding. Judges notice when one party takes unilateral action that excludes the other party before any legal process has begun. It doesn't look cooperative. It doesn't look like someone acting in good faith. "What does Kevin want?" she asked me. "He wants to see his son," I said. "And he wants his house back." "Those are two separate issues," she said. "I know," I said, "one at a time." Kevin had been texting Renata asking to see Caleb, and she had been responding in short, non-committal messages. He had been in my guest room for 2 nights at this point. He was holding himself together remarkably well. But I could hear him through the wall at night, not crying exactly, just awake, the way a person is awake when their brain won't let them stop. We drafted a letter, not a threatening letter, a factual one. It laid out, plainly, that Kevin was the sole mortgagee of the property at the address in question, that he had not been served with any court order restricting his access, that the changing of locks on a property where he held legal residence without a court order was not legally enforceable and could constitute unlawful exclusion under Ohio Revised Code, that he was formally requesting access to the property to retrieve personal documents and belongings, and that he expected to resume normal access within 48 hours. The letter also noted, without elaboration, that the mortgage servicer had been made aware of the situation. I did not write that letter in a threatening way. I wrote it the way I write compliance reports. Clearly, factually, with citations. We sent it by email, with read receipt, and by certified mail to the house. She read it. I know she read it because the email receipt came back within 20 minutes. She did not respond. She responded 18 hours later. Not to Kevin. Her lawyer called the family law attorney I had spoken with, who by that point Kevin had formally retained. The conversation, as it was relayed to me, was brief. Renata's lawyer, and I say this without malice, had given her client incomplete advice and was now in the position of quietly walking it back. The locks would be changed back. Kevin could return to the home. The question of the separation and what it would mean for Caleb and for the division of any marital assets would proceed through proper legal channels. Kevin drove over that afternoon with a copy of the letter and his ID. The locksmith Renata had hired was still there when he arrived. I don't know if she called him or if it was coincidence. Kevin said the man looked uncomfortable. Kevin showed him the letter and the mortgage document he had brought, and the locksmith, without any argument, opened the door. Caleb was inside with Renata's sister, who had apparently been staying there. My grandson ran to his father across the living room. Kevin said he didn't trust himself to describe that part without losing it, so he didn't. I understood. I stayed in the car. Some things you don't need to witness to know they happened exactly as they should. In the weeks that followed, the legal process began in earnest. Ohio is an equitable distribution state, which means marital assets are divided fairly, not necessarily equally, with consideration for each spouse's contributions. Kevin's attorney, our attorney, really, at this point because I was consulting daily, documented everything. The mortgage payments, the property tax records, the history of what had been contributed and by whom. Renata had, over the course of the marriage, deposited approximately $11,000 into a shared household account for expenses. Kevin had contributed, by our estimate, nearly $430,000 in mortgage payments, taxes, insurance, and major home repairs over the 8 years since he purchased the property, including the 3 years of their marriage. She was entitled to consideration for her contributions during the marriage. That is the law, and it is, frankly, fair. But the house itself, the equity, the ownership, the future of that property, was not going to be split down the middle. Not with those numbers. Not with that history. What Renata had been told, I think, was that she had rights. And she did. But rights exist within a system, and that system has documentation and precedent, and it does not respond well to people who move fast and unilaterally and assume the other party has no resources. She had looked at my son and seen a man sitting on the steps. She had not looked further. The divorce was finalized 8 months later. Kevin kept the house. Renata received a fair settlement that reflected her actual contributions during the marriage. They share custody of Caleb, week on, week off, and by all accounts, Caleb is doing as well as a 4-year-old can do when his parents live in separate houses. He is resilient. He has always been a resilient child. Kevin has moved on in the way that quiet, steady people move on, slowly and without announcement. He redid the kitchen last spring. He joined a weekend soccer league. He calls me every Sunday. Renata did not end up staying in Columbus. She moved to be closer to her own family in Michigan. I don't know the details, and I don't ask. There are things I want to say about what I learned from all of this, and I am going to try to say them plainly. The first thing is that acting in a panic is a choice, and it is almost always the wrong one. When Kevin called me from his car in that parking lot, 2 hours after he had been locked out of his own house, I could feel the pull of it. The urge to call someone, to say something, to make noise. But noise without direction is just noise. The situation was not going to be made better by me being upset. It was going to be made better by me thinking clearly. I had to choose that. It was a choice. The second thing is that documentation is not paranoia. Kevin did not have a habit of keeping records of the house expenses because he thought he might need them one day. He kept them because he is organized and because I raised him to keep receipts. That habit, which cost him nothing, was worth more than I can quantify when it came time to demonstrate what he had contributed. If you share a home, a bank account, a business, or anything of material value with another person, keep records, not because you suspect them, because life is long, and Circumstances change, and a piece of paper asking nothing of you now might be worth everything later. The third thing is this. There was a moment, a few days after Kevin moved back into the house, when he called me, and I could hear something different in his voice. Not happy exactly, but steady. And he said, "Mom, I keep thinking, what would have happened if I didn't have you?" I told him that's not the right question. The right question is, what do you do when you don't have someone who knows what I know? And the answer is, you find that person. You ask. You look. You do not assume that what someone tells you in a moment of crisis is the complete picture, and you do not assume that because someone acts with confidence they are acting correctly. People take advantage of the gap between what you know and what they know. The best thing you can do is close that gap. Ask questions. Get second opinions. Read the paperwork. Every time. Kevin had me. Not everyone does. But everyone has access to more information than they think, and everyone has the right to ask a second question after they hear the first answer. Remember that. You do not have to accept the situation as it has been handed to you. I still think about that moment when I pulled into the driveway and saw Kevin on the steps, 41 degrees, one bag, a sleeping 4-year-old on his lap. What strikes me now looking back is not what Renata did. People make bad decisions when they are scared or angry or poorly advised. That is not remarkable. What strikes me is the question of why it worked out the way it did, and why, for so many people in that same situation, it doesn't. The answer is not luck. I don't believe in luck as an explanation for outcomes. What I believe in is the slow accumulation of choices, made long before any crisis arrives. Kevin kept records because I taught him to keep records, not because either of us imagined this specific situation. Because keeping records is a form of honesty. It is saying, this is what happened, this is what was contributed, this is what is real. That habit was a moral choice before it was ever a practical one. And when the moment came that required evidence, the evidence existed. What you do in the ordinary days determines what you have available in the extraordinary ones. Renata made a different set of choices. She moved quickly, without complete information, and she mistook her husband's steadiness for an absence of resources. That mistake cost her significantly in the final settlement, not because the system punished her for being wrong, but because the system reflects what actually happened. She had contributed $11,000 over 3 years. Kevin had contributed more than $400,000 over 8 years. No amount of aggressive maneuvering changes those numbers. The truth of a situation has a way of reasserting itself, eventually, through whatever structure exists to hold it. I think about the person Kevin could have been in that moment, the version of him who panicked, who made threats, who showed up at the house and made a scene in front of the neighbors and gave Renata's lawyer something to work with. That version exists. I have seen that version of other people's sons, and I understand the impulse completely. When someone takes something from you that is yours, the most natural thing in the world is to react from the place of the wound. But the wound is not where your strength lives. Kevin knew that, or he trusted me enough to act as though he did, which amounts to the same thing. What carried us through was not just knowledge of the law or the right contacts. It was the willingness to slow down when everything felt urgent, to ask the next question, to sit with uncertainty for 24 hours while a letter traveled by certified mail. That kind of steadiness is not something you find on the day you need it. It is something you build, quietly, over years of choosing to think before you react. I raised Kevin to be a decent man. He is. And in this case, his decency was also his strategy. He had nothing to hide, no behavior to explain away, no moments of his own he needed to hope no one would bring up. He could stand in the light of exactly what he had done and let that be the argument. That is what I want people to take from this. Not that you need a mother who works in financial compliance. Not that you need to know a family law attorney. You need to be, consistently and quietly, the kind of person whose record speaks for them when the time comes. You need to be willing to learn what you don't know. Ask for help without shame, and hold your ground without losing yourself in the process. Kevin got his house back. More than that, he got to show his son what it looks like when a person faces something hard and handles it with their integrity and tact. Caleb is 4 years old. He won't remember the details. But children absorb the feeling of things. And the feeling in that house, once Kevin walked back through the door, was that it was going to be okay. That was enough. That was more than enough.